So I'm Laura O'Brien. I'm the one who does the estate planning at our law firm here. And a couple of things I wanted to start off by saying is that nothing that we talk about today, none of the legal advice and things like that that I share make a representation contract between us. So there's nothing that we're talking about that means that I'm your attorney unless you decide to hire me later. So that's important for me to say, just for legality purposes. And I think everybody or most people, there's one person who didn't hear me say that I will have a kind of a recap flyer of important things to think about when you're starting your estate planning process and documents that you actually need to have prepared. And because we're going to talk about the different documents. So if you want to get that flyer, if you want to send me a chat in the chat box with your email address, or if you want to email me your email address separately, my email address is laura@MyVirtual.Lawyer, and I will put that in the chat for everyone here. MyVirtual.Lawyer. And if you have any background noise that's happening in your space right now, go ahead and mute yourself. I have the ability to mute you too if I need to, but we're all adults. So I want this to be kind of interactive. I will start by talking about a few things that I think are necessary to know about estate planning, what types of estate planning documents you want and or need, and why I think you need them. And then I really do want this to be interactive and you guys ask questions along the way. If you are more comfortable chatting in the question, please feel free to do that. If you want to go ahead and just verbalize your question, that's totally fine too. So estate planning, I know it's kind of, it may be something that you've thought about every once in a while in your life, but I know times are quite fun right now. And with everything so up in the air, I will say Ryan and I know each other from college. So he's one of the participants on the call. We were talking before other people got on about, when schools are going back to in person. I know it's going to be district by district, and we've got the whole state can potentially be on this call because I think we've got some people from North Arkansas, Central Arkansas. Everyone is welcome because I can talk about Arkansas estate planning. I can't talk about other states. So if you've got things in other states, I can certainly see if I can get you in touch with somebody who can answer questions if you've got property in Texas or Louisiana or something. So let's talk a little bit about there are four main documents that I think that people should be aware of. I think most people think of a will. A will is what we think of when we think about estate planning. That's how you can tell everyone what you want to have happen with your stuff and potentially your children. So if you have minor children, inside of a will, you can actually state your preferences for a guardian for that child, so that they'd still have to go to court in order to get that guardianship approved by a judge, but you can state in your will who you prefer to have guardianship and legal rights to make decisions for your children. If you are married, or if there is a biological other parent in the picture, it does have to be that person, even if you don't want it to be. It does have to be that other person, unless they either die before you or unfortunately, there's like an accident or something and they are deceased at the same time. So just kind of keep that in mind. But that's the situation about a will. We'll talk about that a little bit more specifically. But I want to talk about the other documents because people I don't think about those, may not know about those. And I personally think they're almost even more important to have for you while you're still alive. It's called estate planning, but it's while you're still alive that these documents are very important. So first one, and to me, the most important one to have, is a healthcare directive, or what's also called a living will. That is a document, it's a short document. It's like a 2-page document that tells the doctors and the hospitals what you do or don't want done to save your life or prolong your life if you're not able to express your wishes for yourself. So we're talking about things like keeping you alive on artificial nutrition, artificial hydration, ventilators, which is something that we see a lot in the news right now with the coronavirus. Those types of things you get to say. Yes, I do want them to try to save my life doing X, Y, and Z. No, I don't want them doing A, B, and C. You can be really specific about things like if in a period of 14 days or 30 days that I have no change in brain activity and I'm not, in a state where I'm going to recover or get better, then you express your wishes that you're not kept alive any longer. So, what we're talking about today is a little bit morbid, but at the same time, it's so necessary because we all have, whether we think so or not, we all have very passionate ideas about what we want done to save us and what we also, depending on our own personal experiences, what we don't want to have done to save us. I'll share a little personal story. My stepfather passed away from cancer. He was in the hospital for 2 weeks. He ended up having to be taken off of life support, but it was a mess. It was really bad because he didn't have any documents in place. So my mother was having to make decisions. They were having to wake him up out of a drug-induced coma in order to try to get him to say whether or not he wished X, Y, and Z. That kind of stuff, if you have it in a document beforehand that you either keep on file with a hospital or a doctor, or that someone in your family or a friend can have easy access to be able to bring that, super, super important document. The other two documents are powers of attorney. One is a power of attorney for your healthcare decisions. One is a power of attorney for your stuff, general, financial, that kind of thing. The power of attorney for healthcare cannot trump your living will if you also have a living will. But what you're doing is you're appointing some person, whether it's a spouse or a parent or a sister or a friend, who is going to be able to make decisions on your behalf about medical treatments for you, whether that's surgery or transplants or ventilators or whatever it might be. It gives them that power because we all know, or maybe we don't, but lawyers are not the most popular people out there in the world. And one of the reasons is because we like to sue. And not me, but we are sue people. And most people don't talk to an attorney because they are happy and in a good place and things are really good in life. It's usually something negative. So hospitals are also those people, and they're very risk adverse when it comes to the possibility of being sued. So when you have those documents, that power of attorney for your person to be able to make those decisions for you, it protects them. And also you want to have that discussion with the person that you're appointing. Hey, this is what I want, so that they know and they're not just having to make those decisions without knowing what your wishes are. The power of attorney for your stuff is going to help them have access to bank accounts, mortgage payment, like make your mortgage payments, if they need to sell your house to pay medical bills or something while you're still alive. All of those three documents are while you're still alive. Those come into play. But I think those are equally as important, if sometimes not more important, than having the will. So the will itself is a longer document, obviously. It can be super simple. It can be very complex. It just kind of depends on what you have and what you want to give away and how you want to give it away, whether it's stuff to charity, whether it's, this specific bank account goes to this person, this specific thing goes to that person, my mother's wedding ring goes to my niece, whatever it might be. It can be real specific or real general. So kind of keep that in mind. If anybody has questions about trusts, feel free to ask them. I'm not going to talk about them too much because they're usually not pertinent for most people's situations. I recommend trusts, and there can be simple trusts as well, when people own property, because it does avoid the probate problem when it comes to real property. Real property can be tied up in probate for 3 to 6 months or even more sometimes. So just kind of keep that in mind if you have specific questions about trusts. It's a more complicated document, so it costs more, but it does allow you to say this person gets my house immediately, as opposed to having to go through probate, which is the main benefit for the average folk. So I'm going to stop there for a few minutes and see if you guys have any questions about what we've talked about so far. No questions?
Very well explained.
Thanks. I do this a little bit, so excuse me. I have a cough that has nothing to do with COVID. It is allergies. So super fun. I feel like I have more allergies almost since I'm home all the time. I have an autoimmune disease, and so I've been staying in for 4 months. And I feel like anytime I leave my house, I just catch all of the pollen or the trees or whatever is out there. So some things to think about. I'll just talk a little bit more. Some things to think about when you are deciding what you're going to do with your estate plan before and after, because I've talked about the documents that are necessary for while you're alive and then what is going to do things after your death. Things to think about are, if you have kids, that's going to make a lot of decisions for you on what you need to do. One thing with the will is you cannot leave money, you can't leave your house to your minor children. That's a reason that some people do things in a trust, so that you have an adult who has the ability to make decisions and manage the property, that kind of thing, on behalf of the children, so that they can get the benefit of money or living there or whatever when they reach the age of 18. The age in Arkansas, the age of majority is 18 for both girls and boys. A little tidbit side note, when I was in law school 100 years ago, or 1999 to 2002, the age of majority for girls and boys was actually different. And I can't remember right now off the top of my head if it was girls were 16 and boys was 17, or boys were 16 and girls were 17, but it was different. And I learned about that in my family law class, talking about statutory rape issues. So happy Thursday evening, that little piece of information. So think about the children. Think about, who maybe would be able to take care of them, that kind of stuff. Again, if you don't have a biological parent, co-parent in the picture, that you want to have, or that you trust to have access to the things that you want your children to have, then that's something to think about for the fact that you cannot leave. You can leave things to them, just know that they can't take over any contracts like real property. They can't own real property at the age of 4 or 11 or 16. Another thing that is a good idea when you start thinking about how, getting stuff together for an estate planning process, is having in one place for yourself to actually make the plan, but also for your family members or your friends, whoever's going to be dealing with stuff after you've passed away. Get together in one place all of your accounts, all of your information, whether that's your retirement accounts, whether that's like any IRAs, any bank account numbers, any mortgage information, lender information, car loan, all that kind of stuff you want to have in one place, with contact names and phone numbers, with account numbers. So obviously keep it secure somewhere. Don't just have it on your phone, then leave it in a, I was going to say in a taxi or something, but I forget sometimes. We're in Arkansas, we don't use taxis. In an Uber, we can do the Ubers and that kind of thing. I've lived in Chicago and DC, and even then I didn't even use taxis as much as I used the Ubers and the other things. But have that all in one place, again, so that you know what things are and what you have when you are planning, but also for people to have easier access to when you do pass away. It is one of those things that hopefully it doesn't happen anytime soon, but it will happen for all of us. And the point of this is to have control over your own body, your own life, and your stuff when you pass away. So if you have a brother that you hate, or a daughter who's a drug addict or something like that, you can make those special provisions so that they might not have immediate access to money, but that somebody can take care of them while they're either getting better, or until they get better, or until they get to be 18, whatever the situation might be. I can keep on babbling, but any questions that you guys have kind of thought of, burning questions, and they can be general, they don't have to be specific. If you want it to be, oh yeah, I see a question in here. Thank you for that. The question is, do any of the documents need to be notarized? Every single one of them will need to be notarized. When it comes to the power of attorneys and the living will, they just need to be notarized. So they'll need to be signed in front of a notary by you. And when I say in front of, coronavirus times, the Arkansas court systems have kind of shut down, and they're the only times that people are going in person for situations are emergencies, and that includes notaries. Notaries are now being allowed, for the first time ever, notaries are now being allowed by the government to identify you on video chat. So if you don't have the ability to have a notary, either, because I used to send people to public libraries and things like that when they needed a notary. Banks used to do it. They are less likely to do their clients, their customers notarized documents now. I notice this more with divorces, because I also handle divorces for my law firm. They really are loath to notarize divorce documents, I will say that. So if you have that problem, notaries are not allowed to charge more than $5 for their services. That's the cap on what they can charge. So if anybody ever needs, referral for notaries that are doing the video chat verifying, just let me know and I can get you some names on that. When it comes to the will, you not only need a notary, but you also need 2 witnesses that are disinterested parties, meaning that you can't have a beneficiary in your will also be a witness. So just, don't leave, if you're leaving $10 to your next door neighbor, he or she cannot be a witness. But if they are not getting a benefit from your will, then pretty much anybody can be a witness. They just have to be able to verify that they saw that this is your will and that they saw that that was your signature. And you guys can do that on video chat as well. What other questions do you guys have?
So I have a house and an ex-wife and 2 minor children that are still minor enough that they over 8 more years for the first one die. If I should die in that time, I need to have a trust set up for the, have I understood you correctly?
You don't have to. It's just, in my opinion, it oftentimes is better unless you trust someone. If your parents or if somebody that you know that you can trust, that they would, whether it's your wishes for them to sell the house and put the money in a savings account for the kids, they just can't be in the kids' names. So it's, in my opinion, it's your comfort level. Trusts are about twice as expensive. Even the way that I do them, trusts are about twice as expensive as getting the will and the other documents. And if you've passed away, and the main thing with probate, the reason it takes so long is because in Arkansas, you have to publish the property in the newspaper in order for anybody, any creditors or anybody who has any rights to your, if you have any debt, medical debt, that kind of thing, if anybody has the right to come after the property, then, or, come after your estate for a piece of it, then, so if you want to avoid that, then yes, a trust.
Okay.
That was a lot of words, but that's the main reason that I like to avoid probate, if it makes sense, is because it can pass directly to the person that you have asked them to, take care of your kids or keep that on behalf of your kids. But if it doesn't really matter, if you're not worried about somebody coming after the estate and putting a lien on the, or, inserting themselves into the probate proceedings in order to get money out of the sale of the house, if you're not worried about that, then I think it's fine to have just a will. I will say that if anybody ever receives Medicaid or those types of government benefits, they almost always insert themselves into a probate proceeding in order to get money out of, because there's that look back, there's all sorts of rules about that.
How about student loans?
That's actually a really good question, and I've never had that question. My understanding of student loans is they die with you, because the estate doesn't get any benefit from your education. But let me check on that. I have a friend who I was actually just texting with before this, and he said step number 1, get an estate plan. Step number 2, don't die. Those were his words for you guys. He's a former teacher and taught for 10 years before he decided to go to law school. I thought he was crazy doing that, but doing the law school part, not necessarily the teaching part, but I'll ask him because he's going to know right off the top of his head. I do estate planning and family law, and so I don't know all those little nuances, but I will get that answer back to you, Ryan, and if you guys don't mind, I'll have your email addresses for those of you that have shared it with me, and I'll share that answer with everybody. I've never heard of that, but that doesn't mean that they can't, you know.
Well, that's my biggest debt that I have.
Yeah. Most people's are their house and their student loan.
Well, yeah, there's my house too. I guess it's probably my second biggest debt, but it's still a big one.
Yeah. It's valid. Secondary education is not cheap. And then I have a doctorate, and that's not cheap. And it's, I know a lot of people who are just planning on taking their student loan debt to their deathbed, basically. So my instinct is to say no. Student loan people have no right to come after your estate for the money. But I don't like to say things definitively without checking first. So I will check on that.
I appreciate it.
What other questions do you guys maybe have?
I have something. Say we wanted to go ahead and plan out funeral requests. Is that something that we need to keep on file with our will, or just something that we leave with the funeral home that we choose?
I would say both. It is, I would be very cautious about pre-buying plans with one specific funeral home that, and Jessica, I may talk about that with you separately too. I'm just going to generally say that when my grandfather passed away, they had, everything planned out, all that stuff, and, plots, they bought everything. It went very smoothly. No problems. It didn't their kids didn't have to make any decisions, all that fun stuff. But a friend of mine's a friend of mine's grandfather in a smaller town in Arkansas, this was in Oklahoma, in a small town in Oklahoma, but a friend of mine in Arkansas had bought all that stuff 30 years before or 40 years before with a funeral home that went out of business and got bought by another funeral home. And that funeral home didn't want to honor what the previous funeral home had already gotten money for. They ended up doing it, but only because my friend who's an attorney stepped in and got a little nasty with them. So just keep in mind, if you're going to do that kind of funeral planning, which is a good idea, make sure that you reference that in your will, and make sure that in whatever contract you have with the funeral home, that it's in there that whatever successive funeral home could be, potentially in the future, whatever successive funeral home there is, that they have to honor that. It's just like a kind of a cautionary warning. Oops, as I knock my computer over. I talk with my hands so much. It's just something to think about when you start looking at that. So ask those questions when you are talking with the funeral home about what would happen if in 40 years when I pass away, or hopefully longer for you, hopefully it's 50 years or 60 years, what would happen if you're not here anymore? What kind of safeguards do you have for me, who's handing you thousands of dollars in order to keep this stuff ready? Just make sure you ask those questions and make sure you're satisfied with the answers. If anybody gets mad at you for asking questions, as far as I'm concerned, go away, go to a different place, because you need to ask these questions. You need to really have that knowledge.
Okay.
I saw another question come in. What is the approximate cost for a will? And I'm going to give you a very lawyer answer, meaning that it varies. It depends. And so my law firm specifically does, and this is not a sales pitch for my law firm. I really want people to be educated and feel more comfortable about pretty much everything. We do Facebook Lives that are just about education and things like that every Tuesday on our law firm page. My law firm is what we call limited scope representation virtual law firm. What that means is that we do everything communication-wise. If you hire me to be your attorney, all of our communication is online through a secure client portal with electronic questionnaires, electronic signatures, electronic payments, all that kind of stuff is online. And that includes me not helping you notarize the documents, execute the documents. I just give you detailed instructions on what to do with those documents. So I think the retail cost for one will at my firm, I think it's $300. We do I say retail cost like that's the cost. We're flat fee only. The estate planning bundle for a single person is $750, and that includes all 4 of the documents that I mentioned, not the trust, but the will, the powers of attorney, and the living will. It's $750 for a single person. If you want to do a married couple wants to do both of their documents together at the same time, then that's $1,000. And I'll say it now just because the cost question was brought up. We are very sympathetic to what you guys are the decisions that you guys are being forced into making. And so we're offering a 20% discount on those bundles until the end of August. So the $750 would be $600 for the estate planning bundle for a single person. The $1,000 for the married person estate planning package would be, the $1,000 would go down to $800. If you're talking about full service law firms, meaning, I don't even know what that means anymore with coronavirus times. That used to mean that they would, you'd go to their office, you'd have multiple meetings, you'd execute all your documents there because they have 90 notaries. Even a one-person estate planning law firm has 90 notaries there. So you do everything at their office, and they would walk you through everything kind of piece by piece. Also, if you do a trust with a traditional law firm, they sometimes will help you fund that trust as well. And what that means is like getting your real property, your house, getting a quitclaim deed over. So because the house has to be owned by the trust, all of your stuff that you want to have in the trust has to be owned by the trust. So your car title, your bank accounts, like all that stuff has to be owned by the trust. And a traditional law firm helps you do all that stuff. I don't do that. I give you detailed instructions on it. And so trusts start at $1,250 for me. That includes the other 4 documents because you do have to have a will if you have a trust. So that they start at $1,250. They get higher depending on how complicated your property is. But for a traditional practice, you can usually add on, really honestly, it just kind of depends. I've seen estate planning packages start at $1,500. I've seen them start at $2,000 at traditional law firms. But you'd have to really call around because we're all so different. There's not really standard pricing. And it might be different. I'm in Central Arkansas, so it might be different in Central Arkansas than it is in Harrison or Jonesboro or Fort Smith or somewhere like that. Any other questions? I've got a couple of other things I can say without boring you too much, I hope. All right, so a couple of other things. It is Arkansas, and so there are a lot of people who are landowners, even if they don't know they are. So if you have any relatives or your parents own little pieces of property throughout the state, whether it's just a plot of land out in podunk nowhere, those kinds of things you need to also be aware of. So ask some questions. Maybe even do, deed searches or land searches in the free websites on the Secretary of State's office. Check out your parents' names, that kind of thing, kind of see what they own, because your parents should also be doing estate planning. It's harder, the older they get, it's harder to get them to do this stuff. I've had, unfortunately, my other 2 grandparents passed away without any estate planning, so all sorts of stuff got messed up with that. Insurance policies are another thing to make sure that you have in that group when you're getting all your stuff together so you know what you have. Insurance policies are a big one to have in that because if it's like a life insurance policy, you want to make sure that people have access to contact information and how to get in touch with the life insurance company so that you can get, whoever is the beneficiary can get that money pretty quickly, especially if you need it to pay for funeral concerns and things of that nature. Another thing to keep in mind is, this is not a necessary document, but it's something that can be helpful. It wouldn't work, Ryan, for your situation with minor children, but if you have a piece of real property and you want it to go to a specific person, not like be sold and split amongst your 3 kids or something like that. If you wanted to go to a specific person, you might also want something called a beneficiary deed, which is something that can be on file so that the property can pass a little bit more easily to the specific person that you want it to go to. And these are things that'll be in the flyer that I send out to you guys.
So say I make the will and all these other documents as well, and then 2 years from now, my parents die and they had some property and now that's my property and I need to go back and adjust my will and perhaps other documents. So how hard is that to do? Not
hard at all. If your original attorney that helps you with the documents is still around, they can usually help you, and it won't necessarily cost as much as it did the initial time that they helped you with the document, especially if you're just amending certain parts of the will or certain parts of the trust. They just need to kind of do the new document. Every time that you're going to have an addition or a new, even your first will that you've ever had in your life, it's going to say at the very top that this trumps any other will that was previously executed. And it's going to have a date on it. So you can amend things and change things as much as you want to. And that does happen pretty often. So it's
novels.
Pardon?
That's in lots of murder mystery novels.
Yes. Yes. I watch a lot of Law and Order. It's not always in there, but the murder mystery novels get a little bit more in depth. What other questions do you guys have? We can totally end early. Now's your time. Free legal stuff.
I'm kind of wondering about, for instance, if I get all of this set up and the corona takes me out, and so I have teacher retirements and I have savings and I have life insurance beneficiaries. I have 1 child. So like, I'm kind of wondering, I guess more specifically with the retirement, like, is there a process that I have overlooked in making sure that everything would be funneled the right direction after the fact?
So I'm going to start this with, I am going to post this on our public website. So I'm going to start this with that kind of clarification, because I would have a lot of follow-up questions for your question.
Sure.
If you have a spouse, or if you, like who's the current beneficiary on this stuff,
right.
That kind of thing. So
right.
if you wanted to set up a separate call with me, that's fine. We can have a 15-minute chat or something if you would rather talk about that privately.
Okay.
Just because that's a very
that makes sense.
Yeah, that's not as much a general. Everybody would want to know the answer to that. That's a very specific thing to you. So I just don't want to have you share too many personal things with everybody. So if you want to send me, I put my email address in the chat. I don't know if you can see it. Yeah.
Okay.
Just shoot me an email and we can come up with a time that we can chat for 15 minutes or so.
Thank you.
I am happy. It's one of those things, I'll address this even though nobody asked the question. People often ask why they need an attorney to help with estate planning documents when you can get them either online or at, Office Depot, those kinds of places, and you can pay a fraction of the cost. I think an attorney, now keep in mind, I am an attorney, but I think an attorney is always helpful, if nothing more than for the explanations and for what I've seen. I've been practicing law for a long time, and I've done it in a lot of different areas of law, and I've done it corporate America. I've done it all. I've done it all. I have come across scenarios that I know what is good and what is bad and what will work and what won't work. And so is an attorney who is an estate planning attorney. Don't hire a criminal defense attorney just because he's a friend, because, you know, that kind of thing. They really need to know something about estate planning if they're going to be helping you with your estate planning. I get that. It's kind of like with doctors, and I'm sure you teachers get it all the time too. Somebody's going to ask you like a super complicated biology question and you're a math teacher. You know, hey, look, that's not my thing. So it's the same concept. I know estate planning, I know divorces and custody because that's what I do. I don't know anything about trademark law or, you know, bankruptcy or anything like that. I won't even touch those unless it's like the super easy answer. I'm not even going to touch trying to answer those. So feel the same thing. Just keep that in mind. If you've got friends who are an attorney and they're going to help you out, make sure that they're knowledgeable about estate planning. I think that the extra few $100s that you might spend hiring an attorney, it's just worth it to make sure it's right. And especially if you think that there might be some challenges after your death. That's not the situation for everybody. But even if you think that people will be fine after your death, you'd be surprised, because the stress that goes along with the loved one dying, you know, ramps up everybody's negative sides. It just really does. And it's just best to have everything kind of laid out exactly the way it needs to be so that it can go as smoothly as possible, both with your estate planning after your death, but also for the documents that I've been talking about when you're alive. The documents that, like the powers of attorney and things like that, there are form documents for that are even in our statutes in Arkansas. But again, the explanations of this is what a hospital is going to look at it. This, you know, this is what this means. Here are extra wording that you can add in. You can adjust things as you want. It doesn't have to be that template form that you can get at those other places. So that's just my 2 cents on if you know, it's easy for me to say because I am a lawyer, but we all have our specialties and our jobs for a reason, right? And it doesn't have to cost $5,000. I think that about everything. Things don't have to cost as much as people think they do. I mean, we do the same thing with our divorces and stuff. We don't do retainers, we do flat fees, and you know, people don't get divorced because they think it's going to be too expensive, which sometimes it is. But if the parties are going to agree, you might get divorced for $1,000 with me versus $5,000, $10,000 or more with other people. Because my law firm in general, it was founded by a female lawyer who wanted to help people with access to justice and also have time with her kids, which she wasn't having when she was doing traditional practice. And then when I joined her almost 3 years ago, I don't have kids, but I wanted to have more time to read and play on my phone, take walks and all that stuff. And I had health issues at the time. But so we come at it from a kind of a different direction, but a lot of what we do is education, that you don't have to hire the most expensive. It's not like getting drywall. It's not, just hire somebody who you trust, that you like, that you have a good relationship with, good camaraderie with, that you feel like you can ask whatever question, no matter how stupid you think it is. I promise you I've heard a more stupid question. Any other questions? I'll leave it open for a couple more minutes for questions. And, oh, sorry, I got asked a question and I replied to the wrong person. I'm typing in my email address again. And the chats will not be on the Facebook Live, so I will not be sharing your emails with the world who watches, who looks at our Facebook page. So I just put my email address in again. We don't usually take incoming calls. We do have on our website, it's just MyVirtual.Lawyer. There is a toll-free number that we use an answering service for our calls. I don't take direct incoming calls, so just FYI on that. That's part of why my fees are low, is because I'm not stuck talking on the phone for hours and hours, which I used to do a lot when I did traditional practice. So, you know, we can set a time to talk, but I don't like to be surprised, just like you guys probably. I don't like to be surprised if a client calls in or something, so. And again, you don't have to go any further with me specifically. I just hope that this was beneficial and that, you know, I answered some questions for you guys and gave you some more information on what you can do to protect yourself and have things done the way that you want them to be done.
It was very helpful.
Good, I'm glad.
I do have one question. So I am not currently married to the person that I am expecting to be the beneficiary. Is that going to be an issue for any reason?
No.
Okay.
If you are planning to get married in the near future, then you just would need to anticipate that you'd have to update your will pretty quickly. The beneficiary on whatever, the name doesn't necessarily have to be changed in the beneficiaries. It's not 100% necessary that the will says that you're a married person and this is your spouse when you're talking about the beneficiary being your future spouse, or I'm not a huge fan of marriage just because I'm a divorce lawyer. So if you never plan on getting married and just being, you know, life partners, whatever, it doesn't have to say that you're a married person, but it will initially say that you're either married or unmarried, just because that's kind of the format that we use. So anticipate that you might need to change it if you're going to get married soon, but it's not 100% necessary to change it like immediately after you get married. That is another lawyer answer, and I apologize for that, but that's kind of the gist of it. If the plan is for them to be your beneficiary, if you're talking about beneficiary where they might be jointly on accounts, things like your bank accounts, make sure your bank accounts are also changed to things like payable on death accounts as opposed to joint accounts. Sometimes with joint accounts for married people or for significant others that live together, whatever it might be, sometimes that can cause a problem if the one person dies and it's an and account versus an or account, because you have to bring up like a death certificate to the bank and, do all sorts of stuff to jump through hoops in order to get accounts closed or get money out of things. So just kind of keep that in mind too. That was a lot of words to answer your question, but I hope it did.
Yes, that helped. Thank you.
You're welcome. Well, all right, guys, we're 45 minutes, and I appreciate so much your coming with me this evening to listen to me talk. And if anybody wants to reach out afterwards, I've shared my email address. I will get the email addresses that people have shared and send out a link so that you can get the document. It's just kind of a wrap up it's just a one pager about the things you need to think about and the documents that you need to think about having. And then, feel free to reach out and or take this knowledge to another attorney, talk to your spouse or significant other, talk to your parents. These are not decisions that need to be made quickly. They're things that you want to think about and kind of decide what you want to do. So I appreciate your time, and I hope you guys have a great rest of your evening.
Thanks. Same to you.
Thank you.
Thank you.